Just by way of a bit of a background, I am the Executive Director of Operations for the Federal Circuit Court, but my background has basically been in courts administration since early 1977. I've done 23 years in the State Courts Victoria, working in all jurisdictions there, and I began with the Federal Magistrates Court as it was in July 2000, so about 2 or 3 weeks after they started sitting. The court at that time had about, I think, 10 judges on the day I started. So the court was established, as you'd be aware, to take the pressures off the superior courts, the family court and the federal court, and by any measure I'd say it's been an absolute success. Currently the Federal Circuit Court does 86% of all family law, and when we talk about it in that context, I'm talking about the substantive applications, so the initiating applications and that type of work. In addition to that, we've got the divorce workload, and I'd like to talk about how we're progressing that divorce workload. So there's quite a lot of work in family law for us, and we've got in terms of filings in general federal law, we now get over 60% of filings in the general federal law space, and that's made up a lot of bankruptcy, migration and fair work matters. At full capacity, we have 65 judges in the court now. Currently we're a couple down, we're waiting on some fresh appointments, but we expect those to happen in the not too distant future. The court has the judges appointed in all capital cities in Australia and some regional cities, including in New South Wales. We have judges appointed in Newcastle, we have judges in Cairns and Townsville and other regional centres. We also conduct an extensive circuit program, and in that program we travel to 30 or in excess of 30 locations throughout rural and regional Australia, conduct business in those locations. It's become a big workload. Our estimate is that about 20% of our filings are coming from rural and regional Australia, so there is a significant population out there that we look to provide access to justice to. We also conduct special fixtures in a lot of other locations as required. One of the interesting things we're doing, particularly in circuit locations, and we have a fund that's called, well, we describe it as an administered fund, where we get a fund of around $900,000 a year. It's indexed. We've engaged Relationships Australia to assist us in the provision of property mediation, and we're focusing on rural and regional Australia, where we can deliver more timely services rather than have a roster of someone going out there 2 or 3 times a year. The provider's able to meet in a more timely way with the litigants and fit in with the lawyers in those locations. So that's a service provider model. The mediators are all family dispute resolution practitioners who are also lawyers and have skills in family law property matters. So that's really quite an interesting development that we've progressed in the last few years. In terms of some of the challenges facing the court, from the 1st of July this year, the Federal Circuit Court took over the running of the family law registries. So we've moved from being a receiver of services to being a provider of services to the Family Court and the Federal Circuit Court. And that's an interesting challenge to the court. And particularly in terms of our changing environment. I watched the presentation by Mr. Soden the other day, and he talked about the electronic court file. The judges in the Federal Circuit Court are also using the electronic court file, so we have access to that and the developments that the Federal Court are making in that space. And I suppose more generally, what we're looking at now, we have, I'm sure you're aware, a merging of corporate services between the Family Court, the Federal Court and the Federal Circuit Court, and the Federal Court will become, or is now, the provider of all our corporate services, including IT and IT development. So we're continuing to work with the Federal Court and the Family Court on that development. One of the interesting things we've been working on ourselves for some time now is the development of an electronic divorce file. We get on average around 45,000 applications a year, so it's a significant workload. And we've concentrated a lot of our effort on making access to that via the electronic world easier for litigants. And we've been encouraging more litigants to move to lodging their applications online. So we've made a few changes to that, and in the last 3 months we've moved from around about 25% of filings to around in excess of 50% of divorce applications are now filed online. One of the interesting things around that, or I suppose just to point out some of the benefits in that space, is that we are in Brisbane. We have a total electronic file for divorces, so there's no paper associated at all. We've created screens where in court the registrar can look at the list, choose the matter they want to deal with, all the information is provided, and instead of filling out a paper bench sheet, they make their entries on the screen, and that in turn produces the outcome and in turn the order. So it really makes the flow more efficient, because what we used to do is hand the paper document to someone else and they would enter the matters in the system. So there's some achievements there in terms of savings, in terms of we don't have to order file covers for these matters anymore. There's a whole range of benefits, and there's a freeing up of staff so that we can get them to concentrate on other aspects of the business. I listened to Mr. Day speak the other day, and I thought it was quite interesting. He talked about getting the message out and people understanding the message, the information you're trying to provide. And in the course of encouraging more people to online filing of the divorce application, we revamped the information that was provided on our website. We simplified the information, we explained how to register on the portal, and put a series of questions there that are the most asked questions, and there's answers in drop-down boxes to those questions. And the interesting impact of that has been overnight we dropped the phone calls to our National Inquiry Centre by 20%. And that's a significant number of calls. Once again, it frees up the resources a bit in the Inquiry Centre and gives better access to lawyers and litigants calling that centre. So we're working to develop that further. The good thing with the website is now we have metrics that sit behind that allow us to measure the impact and where the sticking points are for users of the system. So we've identified 2 points. We'll do more work on that and hopefully get a greater flow through that whole system. In terms of the work of the court, we find there's an ever increasing workload in terms particularly of migration matters. The family law has been fairly static for a number of years now. I think Mr. Scarlett mentioned the self-represented litigants. It's really hard to get a measure on the number of self-represented litigants as a portion of the environment. It seems to be fairly stable, but people come in and out of representation at different times. The figures we have suggest that approximately 65% of litigants are represented when they go to trial, and that seems to be fairly stable, that figure. I think the point that Mr. Scarlett made was that they are more difficult. The ones that are not represented, they take longer to manage, and you have to explain things through the system for them. Obviously, the workload in migration is a challenge for the court. That's been increasing over the last few years significantly, and there's a lot of work in that space to be done. It's a constant workload for a number of judges in Sydney and Melbourne particularly.
Are you seeing a lot of unrepresented litigants in that migration space?
There will be a lot of unrepresented litigants, I suspect, but I haven't got a measure on those figures, unfortunately. That's some of the data stuff that we're working on now. We've changed the corporate environment to try and get it. So I don't want to mislead you by giving you a number.
Yeah, no, that's fine. And are there particular challenges presented with migration clients who are unrepresented?
Look, I expect no. There will be challenges. Obviously, being able to understand the language and being able to communicate, we have challenges with interpreters and making sure that people are available to advise litigants. So there's some of the challenges that come with self-representing in that space.
Is there any? You mentioned before that you've got your magistrates doing direct entry of data. Judges, sorry.
Registrars in divorce matters. Registrars in divorce matters. Yep.
So your judges are not doing direct entry of data themselves? Okay, all right. No. Can you see that happening in the future? If so,
It's a little more complicated. In the state courts, you might impose a penalty of $20 or whatever the figure might be, but it's a little bit more complex in terms of family law. In putting data in, there's a series of orders that need to be built into the system, and I really can't see judges moving to that position.
No.
So, have you short some judges? Is that coming from the lack of funds from the federal government, or is it a concern with the delay, or people waiting longer and not getting access to justice sooner?
Well, we have had a number of judges retire recently, and they haven't been judges appointed to replace them yet. And I expect there's a range of factors that sit behind that. In terms of the workload, obviously, if there's less judges,
There's a backlog.
less capacity, and you can see a bit of a correlation. We've had some, in the last few years, we've had some judges off with various illnesses, and for significant periods of time, and you almost see a direct correlation with the time they're away and the growth in the pending numbers.
There's been some coverage in the media about, a very small number of Federal Circuit Court judges about whom that there are complaints. I'm not asking you, of course, to comment on any of those individual judges at all. If this were in New South Wales, for example, there's a judicial commission and complaints kind of get funneled that way, and there's a process there, but in the federal jurisdiction, there's no equivalent kind of to a judicial commission. And so when there is a complaint about a judge, it's a much kind of trickier process, I think, for the complainant to make their complaint. But I wonder whether it's also trickier for the court as well to deal with complaints about individual judges, because there's no way of doing it at arm's length from the court itself. Are you able to comment on that at all?
Not really. I'm at arm's length to that. The judicial complaints are obviously managed by the chief judge of the court, so I can't really make any comment on that.
Okay.
One thing, over the past 15 years or so, we've seen the curtailment of pre-filing counselling services and information services being provided by the court, probably due to limited resources. What do you think has been the impact on that? Do you think a greater focus on informal dispute resolution
I suspect the family relationship centres had an impact. They certainly did on filing numbers initially, and there's a couple of reasons that may have happened. Initially, there were delays in getting into the FRCs, and that may have created a slowdown in filing initially, but I suspect, although I don't know for certain, that they have taken some of the easier matters and been able to resolve them rather than people have to file applications with the court. As I say, we've been fairly steady now at 17,500 initiating applications per annum for the last few years, 4 or 5 years, I think, from memory. So I think when you talk about the pre-counselling mediation that used to happen in the court, I think that's happened largely around the establishment of the FRCs and that being provided before people get to the court, which I personally think is a better place for it to happen. Sorry, what was the other part to?
Oh, look, do you think there are other alternatives like online dispute resolution? Do you think that is something that you're going to see more of?
I just reiterate again the provision of information, and I think our experience with the electronic divorce and how we provided that information and the reduction in calls gives us a significant lesson, and that we need to provide information better so people can see it better. We're also producing a series of videos that we put on YouTube that explain various processes to people, such as how do you serve documents in family law. So there's different ways of doing things, and I think our environment's changing. That there is a generation of people now with an expectation of doing more online rather than coming into a registry, and they expect to get the information they need online.
Right, so I think finally, I'd like to ask, what do you see the challenges are that are facing your court into the future, and if so, what solutions do you suggest?
The challenge of moving into the e-world is one challenge. It's going to keep presenting itself to us over a period of time as we work to develop better systems, and the systems will have an impact on litigants and lawyers as how they deal with the courts. I think that's a big one. It's pretty hard to move away from the fact that we've got a growing workload and migration, and that is a constant challenge, and just getting through that work is, you know, an everyday thing for a number of judges, and personally that concerns me, the volume of work in that space. So they're I think the main challenges that we need to cope with. And I think one of the things is, if we could be certain that when a judge retires, another judge would be immediately appointed, we wouldn't have to do things like wind down the workload of a judge for 6 to 12 months, depending on the judge, prior to that new appointment, and that has a bit of an impact and a bit of a slowdown on our clearance rates at work.
I heard you describe it as a business, so earlier, so you just look at the whole thing as your
No.
budgetary...
No, I don't. I'm very familiar with courts. I've worked with judges, lawyers, litigants for a number of years, but in a sense there are some aspects to courts now that you do need to function as a business. You need to manage your finances. There's an expectation that you'll change in line with the changing environment, and you'll do more with less. So all that sort of stuff impacts, and if you think of it from that perspective, part of it is business, but you really need to understand that you're working with a court, you're working with judges and people who come to a court because they have needs. So we're trying to best meet them.